Hi, I'm Nick Church and welcome to Top Table. These Top Table interviews show the personality and the people behind the best wedding suppliers in the region. But today's a bit different because I have with me law firm partner from Henriques Griffiths, Sam Mayer.
Hi Nick.
Hi Sam. And so why have I got a lawyer on? That's an excellent question and I'll explain right now. COVID-19 pandemic is really hitting the wedding industry hard and loads of weddings can't go ahead, so I know you're suffering with that and businesses are suffering as well. But I'm hearing from loads of you that say you're having difficulty with your venue and how you're being treated when you're trying to cancel that service. Not all venues, I know loads of venues are being really supportive and reasonable throughout this process, but I think there are a small minority that seem to be doing the wrong thing. As well as a wedding photographer, I also run business coaching sessions for photographers and other creatives. So I'm often talking about how the Competition and Markets Authority, the CMA, is there to protect consumers that have ordered a service and what their rights are when that service needs to be cancelled. There are two key points within the CMA guidelines which seem to be the basis of a lot of the problems that you're having with a small minority of venues when it comes to booking. The first is actually who cancels the booking. Now, if the venue cancels it, then you are in a much stronger position. If you cancel it, though, it depends on why you're cancelling, but all is not lost because there are things in place to make sure, whatever reason you cancel your booking, that you are protected to a certain extent. The other thing is contracts, and many couples are signing contracts and being told that they've signed a contract, which means they have to pay out all the money, regardless of what happens. But if a contract is deemed as unfair by the CMA, then it may not be enforceable, and that's also something that protects you from making sure you can get your money back. Probably a good time to introduce Sam Mayer again now and actually get some expert advice on this thing, which is the whole purpose of being here. Hi Sam, and thanks for joining us today.
Hi Nick, nice to be with you.
Sam, do you want to just give us a very quick background about Henriques Griffiths as a firm?
Yeah, of course. Yeah, Henriques Griffiths is a medium practice with two offices. I'm based in the city centre office in Portland Square in Bristol, and we've got another office in Winterbourne in South Gloucestershire.
Okay.
I'm the partner in the litigation department, so I deal with a wide caseload of general contractual disputes.
So you're the right person to have here then for these questions we got coming up.
Absolutely, indeed.
This is going to be general guidance, right? It's not specific legal advice to couples. I have got some scenarios though we're going to put to Sam because I think these scenarios probably include most of the issues that you're facing. Before we jump into those though, I think it'd be worth going through where the law stands and how the law is there to help us. Could you just give a summary of that, Sam?
The first is contractual. So in the contract, there could be what's called a force majeure clause.
Okay.
It's something that the parties is outside their control. Mm-hmm. And if you have a force majeure clause, that may be activated by something like the pandemic, the COVID-19 situation.
Okay. So the first port of call then is if this force majeure clause is in there, then that's the first. That's your first calling point, really. That could be the way out of that particular contract. Indeed,
yeah. It tends to be more of a commercial thing, but it's a creature of contract. So if it's not in your contract, then forget it. It's not going to help you.
Okay. So let's assume then that is not in clients' contracts. What else is there in the law that protects them?
So the next line of attack that may assist could be the general legal doctrine of frustration. Now, it's a good word to use when you're having to cancel your wedding, but in the legal sense, it means that, again, something outside the party's control has happened that wasn't foreseen. It materially changes the contract, and really it's quite a high bar.
Right.
It means that the contract is effectively impossible, that it can't be performed, or possibly that one of the parties' obligations has been radically changed, but it's something that has a big impact.
So if a wedding can't go ahead because of restrictions in that area, say they've gone to tier 3 or whatever, and that wedding can't go ahead, then would that be considered frustration?
I think it would, yeah. Certainly if you've got government regulations that are preventing a wedding from happening, either because venues are forced to close, as has been the case, or numbers of people can't meet sufficiently, then I think that would be considered, something that prevents that contract going ahead. Right. And you may be able to rely on frustration.
So that sounds to me, as a layman, and I think most people watching this would be in the same camp, I guess, that so if something can't go ahead, you've got this frustration clause, but what if the couple don't want to go ahead and the wedding could go ahead, they just don't want to. That then would that be at a point where maybe frustration wouldn't apply?
Yeah, frustration. It's got to be something that's linked to the pandemic. So it's not a case that I can't quite have the day that I want, or there is some uncertainty as to what the regulations will be this time next year.
Yeah.
Then that's much less likely to be frustration. Yeah.
If that frustration then isn't something that's relevant, what's the next step?
Well, the next line of defence is potentially consumer legislation.
Mm-hmm.
So they're protected by the Consumer Rights Act 2015. And what that really means is that if you have signed a contract and it has clauses in it which are very unfavourable and are deemed unfair by the court, then those clauses will be unenforceable. The sorts of clauses that we'd be thinking about there are primarily where you've paid all the money up front, you're giving a sufficient amount of time to cancel, and you've got cancellation clauses that say the venue keeps all the money, even though it hasn't necessarily suffered particularly any loss. Or there might be punitive cancellation clauses that say you pay your deposit, you don't get that back, and then to cancel you have to pay an extra amount, cancellation charge. If it doesn't reflect genuine loss or charges that the venue has incurred, as you mentioned, managing the booking, possibly pre-purchasing items or food or those sorts of things.
Sure.
If they've actually incurred a loss, that's clearly going to be something they can reasonably charge the consumer for.
If the contract cannot be seen as being frustrated at that point due to some external event, meaning that the contract cannot complete in its current form, then that's frustration. If you just want to cancel for some other reason, and whatever reason that is, presumably, is neither here nor there really, it's then being asked to pay either extra money to cancel or to pay the whole fee for the service not delivered, then that could be deemed as unfair, and that contract clause then wouldn't apply if it was found to be unfair, and that would be a court decision, would it?
Obviously, no one would wish to go to court unless you've got a pathological love of litigation or you're a particular fan of crime dramas. The first port of call is going to be to try to negotiate.
Yes.
And obviously part of that negotiating tool is saying, I've got a strong case.
Mm-hmm.
This is what the CMA guidelines say, which I would refer people to. This is what the position in law is, and this is how it applies to my circumstances, and I would win at court, therefore please be reasonable with me, forcible.
I will put the CMA guidance in the description, a link to that, to get it.
It's well worth a look. It really is very helpful. Yeah, it's worth saying it's not statutory, so it's not a formal expression of what will or won't happen.
Mm-hmm.
It's not a reflection of the actual law, but it is very helpful guidance as to the approach that would likely be taken by courts, and it just gives some helpful tips and pointers.
Yeah, if it's shown that there is a pathway that may end up in court, then that's going to be quite a powerful thing.
It is indeed, yeah.
So do you mind if I go through these scenarios then? I've got 3 scenarios which are a general theme of what I'm seeing a lot of in various Facebook groups and brides that I've spoken to. Okay, so scenario 1, there's a wedding was booked in July 2020, couldn't go ahead, postponed to May 2021. Now, the interesting thing here was that the July 2020 date was a Saturday. The new date, as is often the case, Saturdays aren't available. And so they wanted to cancel that wedding, and they were told they couldn't do that without losing everything. So the choices given were to cancel or they would choose a new date. So in fairness to the venue, they were offering, if that date wasn't good enough, they were offering an alternative date. And they were saying your only other option is to cancel and claim on your insurance. How would they stand on that one, do you think?
If they're getting a weekday, not a Saturday, then arguably it's slightly different and less favourable. Should they be paying the full amount that they would have paid for Saturday for a weekday? That's certainly a question to be asked in that case. Mm-hmm. I would argue that they shouldn't be paying the full amount if they've paid upfront for a
premium for a day. And would that apply to also if they've paid for 100 people and they're now paying for 30?
Well, absolutely, yeah. Depending on how the venue's charging structures work.
Mm.
Certainly, if they're paying per head, if if you're going ahead with a smaller event, then certainly arguably that should be a lower charge.
What though if they say, do you know what, we don't want a Thursday, or we just want to regroup, let's replan and we'll plan for 2022, 2023 beyond the pandemic? What's their position then?
Well, certainly if it's a matter of personal choice, then its frustration sort of fades into the background. But regardless of the reasons for cancellation, the Consumer Rights Act still steps in to assist the consumer.
Okay.
So if they choose to cancel, they should do so, and they shouldn't be unfairly prejudiced by that. And that's where the Consumer Rights Act may step in to even up the balance a bit where there is an unfair clause in respect of the charges that would apply in that scenario where they have chosen to cancel.
What we seem to be saying with that scenario, which is a really common one then, is that you've decided not to go ahead because for whatever reason, whether it's uncertainty around COVID, the numbers aren't going to be what you want, or for any other reason it's not the right day, if the day's significant and you can't get that date. Frustration may be sort of falling away as your option, but the safety net is always the consumer rights legislation. Am I right in thinking, Sam, that the argument that I've heard many suppliers give is, well, I'm going to charge you in full because I won't be able to fill that date now because it's too late? That's not really a valid case. That's not counted as an unrecoverable loss.
No, I don't think it is really. It's unfortunate. It's a fact of life, isn't it? And it's going to be a fallow period for the venue.
Yeah. The longer you leave it before you cancel, make that decision to cancel, then the venue is more likely to have incurred costs because they're more likely to have bought supplies or hired staff or whatever else it might be.
Absolutely, yeah.
Okay. All right, good. So on to scenario 2. A couple wanted to cancel but were told they would lose £3,000 plus their £4,000 deposit. So they went for a new date in the end. Now they didn't, again, I think they ideally wanted to cancel, but that wasn't presented as an option. They're now wondering whether they would have had a case back then. Now, is that true that they would have had a case to cancel? Sounds like it is from the previous scenario.
Yeah, I mean, again, though, we're looking at is the amount that the venue is charging, both retaining the deposit and charging a cancellation fee, does that represent actual loss to the venue? It sounds like that would be probably unreasonable,
right.
More of a punitive charge, rather than actually reflecting the loss that the venue incurred.
This is really great advice for couples that are in that decision point, they're in that crossroads, they don't know what to do, and this is really helpful. What if a couple, which I think this scenario might actually be an example of, is the fact they've made that decision important, or has agreeing to a new date gone against them in some way?
If they have now had a change of heart, then the situation remains the same in terms of if they were to cancel now, they may face the same challenge from the venue, and they can make potentially the same arguments if they're unfair clauses that the venue is relying on.
Yeah, okay. So has a venue delivered a service? If not, have they retained a reasonable fee for the work they've done, or have they gone over the top?
Of course, if it's rearranged, and there's more argument for the venue to say, well, we've recently put quite a lot of time into this and so on, in terms of loss.
Yeah, true. The more times you have a conversation with them, then they're going to find it to say, well, you have ranked up quite a lot of time here. So the last scenario is that the original date couldn't go ahead. They didn't want the date that was offered, and they weren't able to cancel. So already we've gone past that point where that frustration could have been relevant, because it sounds like their date couldn't have gone ahead in any case. Right. So again, just before I go into the more detail of that, even though that's now gone past that point, can they still say, well, hang on, we now understand that original contract, that original date, we could have that contract was frustrated in that sense?
Well, the original contract, I guess, was frustrated because, of course, the event couldn't go ahead on that date. It sounds like in that case, though, it's been agreed that it would simply be postponed.
Right, yeah.
So they've come to a sort of further agreement in terms of varying that original contract. So it sounds like they've changed the agreement, so it's a new agreement, so they can't sort of automatically unravel.
That's interesting, right? So if it's you're changing your date and then for whatever reason you decide that, then you're always going to be covered by those CMA guidelines. The frustration clause, though, if you agree some way forward, then you've essentially sort of settled on that.
I think you probably have. Yeah. I mean, frustration is saying that the contract is dead.
Yes.
Essentially, that it cannot be performed, and therefore the contract is cancelled to the extent that it almost never existed.
But to agree a new date and to be collaborative with the venue, you're kind of going around that, and you've gone past the point.
You are because you're kind of you're effectively keeping the contract alive by saying, well, we'll just move the date.
Yeah. I think that's a really useful distinction. That I think they do want to cancel. The reason they didn't is because the venue wanted £8,000. Which 2k of that was their deposit, so £6,000 was a cancellation fee effectively, and the venue say they're not going to pay any back because their insurance should cover that.
Yeah.
What's your view on that?
Well, of course, that's not a reason for the venue to refuse to pay back money that otherwise it should do.
So in that case, then the 6k cancellation deposit is probably unfair. That you shouldn't pay that. Also, the claim that you should claim insurance is also null and void as well, because they're two separate things and one can't refer to another. So there's a couple of angles there. What we're picking up, though, is that it's quite important not to make any decision with a venue before you've really thought about it. So don't jump for a new date. By jumping for it, you may go past the point where some of these options are available. What should people do if they are about to approach a venue? And is there any kind of general advice?
I think you need to be clear on what you want. What do you actually want to achieve? Have you made a decision to pull out, or do you want to try to negotiate and for the event to go ahead in some way, shape, or form? And to what extent are you prepared to vary?
Emails are good because you're keeping a track of things, and the general advice, I suppose, always holds that whenever you are requesting something formally like this, then give a date by which you would like a response, so that it doesn't just drag on for ages.
Absolutely. I mean, if you've got to the stage where you're making offers or you're negotiating or it doesn't seem like they're quite prepared to meet you halfway and you're pushing them to make a decision, then clearly if you're putting that in writing and you're going to want to put a deadline on that so that things don't drift.
Yeah.
And you know that when that date passes, they haven't responded, you may need to take another step or escalate matters. If you are negotiating as well, it's always helpful to mark things as without prejudice. So if it's in writing, it's without prejudice, that means that anything you say in that, if you're trying to negotiate, isn't going to be sort of legally binding on you at a later stage or admissible in proceedings.
Well, so literally put without prejudice at the top of the email?
Yeah.
Okay. Yeah. That's good advice as well. So let's say then that's been done. They've reached a point, and you get to an impasse where there's just a dispute. Go to a solicitor that's going to have the expertise in this field. You've got Sam Mayer from Henriques Griffiths. There's others, but I will put Sam's details below so people can contact. I think there's a worry that they're going to end up paying more than they would have saved. The venue are taking in legal fees. What's your advice on that front?
I'm very happy to speak to people over the phone, so it's always good to have that first conversation. I'm happy to do that free of charge, and I'm always happy as well to have a look over some papers, have a look at the contract, have a look at any correspondence, and give you my view, and give you an appraisal of what the likely costs are going to be. Happy also to agree sort of fixed fees and things like that. It certainly wouldn't give me a great deal of job satisfaction if my fees were going to exceed what the consumer got back. But if the first stage is to go ahead and write a formal letter to the venue, that needn't be hugely expensive, and clients have always got the option to continue or not. Sometimes it has a desired effect. sometimes proceedings are necessary. And obviously, if the advice is to go to that next stage, then clearly the prospects of getting the costs back and the prospects of success and the amount of money at stake are all issues that would feed into that initial advice as to what to do. But this, often starts with a phone conversation, and that's always why I'm always happy to speak to people on the phone and see what the best way through is.
Yeah, certainly. I think that showing that you have legal advice through a letter from a solicitor is going to have massive weight. For the best will in the world, however formally or strongly we all word an email, if that's a letter from a solicitor, then that's going to have a much greater effect. And it shows that there's a pathway, that it doesn't just end at that letter, that there is going to be further steps if required. And hopefully, as we said, that is enough, and it won't get to that point.
Yeah.
All right, that's been really valuable advice. I really do appreciate you, I'm sure everyone that's watching will appreciate your time as well, Sam. Again, I'll put Sam's details and email in the description below. So just to summarise then, this advice was for wedding venues but applies to all suppliers. Now, the majority of suppliers and venues are doing the right thing and are working really hard with you to get what you want and get the wedding that you want. And if you don't want to go ahead, then they're giving you a fair amount of your money back. Now, there are some venues, it seems, that aren't following these guidelines, but the law is there to protect you, as are the CMA guidelines. Remember that these venues are run by real people with families and worries and business worries and money worries, so there are things going on underneath the surface. But if you get to that point where you're in dispute with them, or you feel that you're being treated unfairly, then I really do advise giving your lawyer a call, give Sam a call or another solicitor. Now, and as Sam said, he'll give you a free consultation where you give him all the details, the background to the case, and he can let you know what the cost is going to be, whether you've got a chance to succeed, how much you might be able to get back, all before you start paying any legal fees. So it's really a no-brainer. So that would be my advice. So thanks once again for joining me at Top Table. Now listen, we've got a great selection of wedding guests booked in for the new year. I've got a pickpocket, a musician, a wedding chef, cake maker. So do subscribe to the channel so you get notified of all of that content as it gets made. The next video up to be edited and released is Darren Campbell Magician, so that's a really fun one, so do look out for that one too. So all that remains is me to say Happy Christmas from Nick Church Photography and Top Table, and here's to a happy and healthy 2021.